Hello, everybody. Thank you so much for being with us. My name is Cameron Smith, and I'm a partner in Seyfarth's New York City office. My practice focuses on employment litigation and counseling in our labor and employment department. I'm joined today by two of our superstar associates, Victoria Vitarelli and Kaveh Debashe, who are also in our labor and employment department in New York City. We are also very excited that Keisha Mays, Senior Associate General Counsel at United Health Group, is able to join us as a panelist today. Keisha focuses on UHG's Optum business, which has over 160,000 employees in the United States. And she brings tremendous practical employment law expertise, and we're delighted you can join us, Keisha. Many of you may be aware that Seyfarth experienced an aggressive and sophisticated malware attack, ransomware attack over the weekend. We have no indication that any firm, client, or any firm or client confidential information was accessed or taken, but as a result, in a precautionary measure, we've had to shut down some of our systems and our email while we work to address the attack. So for all of our clients on this webinar today, we're particularly delighted to be able to connect with you. Thank you for your patience. We're working around the clock to get our systems back up so we can continue to serve you without interruption. If you're having any problems at all contacting your Seyfarth attorney, there's a ribbon at the top of our seyfarth.com external webpage where you can get more information and contact any Seyfarth attorney that you may need. So just as we get started, some logistics. Our presentation today, is really to share information, general best practices, but many of the scenarios that we're going to be talking about today and the issues that we're going to be talking about today are very fact specific. So we're not providing any legal advice on the webinar today, and to the degree you have any specific legal questions, please feel free to reach out to us. We'd be happy to address those. There will be opportunities also for you to ask questions today using the chat function on the WebEx system, and we'll try and address those throughout our presentation. And those questions that we're not able to get to during the presentation, we'll make sure to follow up with you individually after today's talk. Today's presentation is eligible for CLE credit. I'll be reading a CLE code closer to the end of our time together today. So please pay attention to that because I'll only be reading it once or twice. Okay, so political speech in the workplace is obviously top of mind for many employers. We're living in a particularly polarized moment in the midst of a global pandemic, just 3 weeks out from an election. Social movements in the wake of the murders of George Floyd and Breonna Taylor and others have sparked conversations at work about race, about policing, about politics. We're going to talk about ways to navigate issues that are coming up with increased frequency among coworkers, and we'll explore hypotheticals to illustrate some of these trickier situations and potential approaches to addressing employee conflicts and political speech. Throughout the presentation, we'll also have a series of polling questions, and we invite you to respond to those. A window will appear in your WebEx screen and you can vote anonymously in response to those poll questions. Today, we're going to cover the First Amendment and the degree to which it applies in the workplace. We'll be talking about anti-discrimination laws and their nexus with political speech. There are a number of state and even city laws that extend protection to off-duty conduct and political expression. We'll cover those. We'll briefly touch on religious and political objections to training or policies on inclusion and diversity. We're going to talk about the National Labor Relations Act and how it applies to politically charged conduct, and then get into some tips for managing political speech in the workplace and on social media, as well as tips on how to handle and diffuse political conflicts at work. So with that, I'll turn it over to Kaveh to discuss our first topic regarding the First Amendment. Thank you, Kaveh.
Thanks, Cameron. So most conversations, unsurprisingly, about speech begin with the First Amendment. Although most people are fairly surprised to learn that the First Amendment only applies in a fairly narrow set of circumstances. Originally, the Bill of Rights was drafted to address the concerns of people who did not want a strong central government. And so, they had the British monarchy fresh on their minds, and with the opportunity for a fresh start in America, wanted a set of laws restricting the government from infringing on the rights of its citizens. So the First Amendment restricts the government's ability to infringe on our right to speak freely. What that means in the employment context is that the First Amendment only applies to government employers rather than private employers. This comes up most often in the context of a retaliation claim, where a government employee claims that the employer disciplined or terminated him or her for engaging in speech that's protected by the First Amendment. The main issue when analyzing something like this becomes whether the public sector's employees' speech was on a matter of public concern. Balancing test that gets triggered here, but generally, if the speech is on a matter of public concern, it's more likely than not that the speech is protected by the First Amendment. So for political speech, the answer is pretty easy. Pretty much all political speech, by definition, is on a matter of public concern. There's an interesting exception here for jobs requiring political loyalty, though. The theory is that some jobs require the employee to hold certain political beliefs in order to perform their job effectively in the first place. So, for example, if a Democratic mayor finds out that her chief of staff regularly publishes pro-Republican posts on Facebook, then it's more likely than not that the mayor can lawfully terminate the chief of staff for that reason, because there is, a political loyalty requirement inherent in that job. Private employers, on the other hand, aren't bound by the First Amendment. They can generally regulate workplace speech per their preference. And that does also include expression through dress code. So, for example, a MAGA hat or a Black Lives Matter face mask, unless there is a state or local law protecting employees' political expression, which we'll get into a little bit later in the presentation.
Great, thanks, Kaveh. And we're going to publish our first poll, so please, as I'm speaking, take an opportunity to respond to that. Kaveh, we'll talk about that last point that you raised a bit later in the presentation, because as Kaveh noted, while the First Amendment doesn't apply to private employers' restrictions on speech in the workplace, several state laws may prohibit employers from disciplining employees for lawful off-duty conduct or political activities or speech that supports or expresses opposition to a political candidate, a cause, or a social movement. So our first poll question is whether or not your company has a political speech policy. And I think, Mike, when you're ready, I think we can publish the results of the poll. But there are a variety of reasons that companies might want to restrict political speech at work expressly. You know, for example, a company might find that allowing political speech at work, particularly as expressed through things like masks or hats or pins, just causes too much conflict and interferes with productivity. Alternatively, a company might view political speech as a way for employees to express themselves or as a way to connect with customers to enhance its brand. So we're curious to know how many private employers in our audience have a policy that specifically addresses political speech in the workplace. And based on the results of the poll, about 67% of you said that your company does not have a policy regarding political speech. This is consistent with a recent study that was reported by SHRM that suggested 79% of employers do not have such policies that expressly extend to or cover political discussions. Keisha, let me turn it over to you. Does this seem consistent with what you've seen from your perspective as an in-house attorney? Do you have thoughts on whether there are policies that work best when it comes to political speech?
Mm-hmm. Yeah, thanks, Cameron. Yeah, it does seem pretty consistent. And it's interesting because we are currently in the midst of what I think is one of the most politically polarized times that many of us have ever witnessed. And so people spend a significant amount of time at work, and to think employees don't or won't engage in political speech at work, I think is somewhat naive. That said, I think a lot of companies shy away from implementing these types of policies because, as we'll see during our time today, these are tough issues to grapple with and resolve. And there's a lot of gray area. And so for those reasons, creating a sound political speech policy can be quite challenging, but I think it can be done. And one of the primary upsides to having a policy is that those of us who manage these issues will have a roadmap when these situations arise. And that decreases the possibility that you're in reactive mode and you're trying to cobble together or identify which policies are implicated while you're in the midst of trying to work through a particular matter. So with regard to what works best, I think like any good employee policy, a policy addressing political speech should be legally compliant, number one, state the purpose or the reasons behind the policy, include clearly defined expectations. I think it should be user-friendly, and by that I mean it should be easy to understand and it should be accessible. And because we can never address every situation within a policy, it has to have some level of flexibility. And certainly that's for those individuals who are trying to manage the policy or manage situations that would be implicated by the policy. And then finally, and I think especially with regard to policies like this, the tone should be reflective of the company's culture. So those are some of the things that I think you'd want to think about. And to the question on whether there are alternative outlets companies can offer for political speech, right? Say a company doesn't want to have this type of policy. The question becomes, or they have a policy that says we just won't do it here. You shouldn't be having kind of these side conversations. I think that'd be very, very hard to manage. But I think there are alternative outlets that companies can offer. So for example, employee resource groups, targeted listening sessions, facilitating courageous conversations about specific topics. And certainly these options aren't without risk. I think they are risky. I think people can be a little bit nervous and anxious about that. But there are certain times where I think these can be helpful. So I think a good example of a targeted listening session could be, allowing a targeted and open discussion after an event like the death of George Floyd. And so that'd be an opportunity for employees to be heard and express their views, to have some sort of release, if you will. And at the same time, I think it allows employees to feel seen and not feel like they have to engage in some whispered conversation about something that has an impact on our larger society and that is truly happening all around us. in real time. So in any event, I read an article that had some good guardrails around these types of conversations if employers want to go that route. And I'll read them here. It's that these should be conducted when people have time and the space to listen to each other. I think that is very important. That all parties must have humility and a willingness to listen, and that all parties are reminded that this is a discussion and not a competition. More importantly, that the goal is to listen and to be heard. And though persuasion is possible, that persuasion is really in the passenger seat rather than it being the driver of these conversations. It's really about allowing individuals to listen and to hear other viewpoints.
Thanks, Keisha, that's great. We got a question from somebody saying, how is political speech defined? And that's, we've been talking about that as panelists, and about the fact that that's sort of at the crux of why this can be so tricky. For many people, they understand and define, for example, the Black Lives Matter movement as a peaceful social movement, and not necessarily a political position. Other people disagree with that. But I think that to the degree companies are thinking about having a political speech policy, one best practice would be to define exactly what it does extend to. Does it extend to support for a political candidate? And and there's no one size fits all application here. You can imagine policies that might allow employees to wear a pin that says Biden 2020 or Trump 2020, and that's it. Or that permit broader expressions of support for peaceful social movements. But the definition of political speech has unfortunately become political. Let me turn it over to Victoria, who's going to be talking about anti-discrimination laws and their application to political speech.
Thanks, Cameron. Okay, so as you know, there are various federal anti-discrimination laws that protect employees as well as job applicants from discrimination based on race, color, age, sex, national origin, disabilities, and those are just to name a few. And those are through Title VII, the ADA, ADEA, whichever apply. Federal law does not expressly prohibit discrimination based on political speech and expression. However, political speech may relate to characteristics that are protected by federal law and other state and local anti-discrimination laws. And that's where it kind of gets a little dicey. For example, we've certainly seen claims where plaintiffs argue race discrimination or retaliation on the theory that Black employees are being disciplined disproportionately for wearing Black Lives Matter masks, but white employees are not being disciplined for wearing statements of support for other social movements. Anti-discrimination laws may intersect with political speech in a number of ways. It's important that workplace policies in this area be uniformly enforced regardless of an employee's protected characteristics. So uniformity in application and enforcement is really critical here. And it's regardless of a protected characteristic. Selective enforcement of workplace policies against some political speech may invite claims of discrimination or harassment, and employees may believe that they're really being disciplined for their protected characteristics, not their politics, and those that are intertwined. And that's really what can become challenging. On the other hand, there's also speech in the form of logos and flags and statements by employees in the workplace, which may create a hostile work environment. If other employees are offended by these statements or view them as evidence of bias targeted towards a particular group, that becomes an issue. Employees cannot allow speech and expression to create a hostile work environment, even if that expression or speech touches on current political themes and issues. Of course, harassment can arise based on what individuals say, but as mentioned, it can also be based on displays of symbols that are considered offensive, harassing, or intimidating. For example, the Confederate flag, which in the most recent months has been really a topic for discussion. And in this discussion, the EEOC and some courts have found that the symbol may contribute to hostile work environment, meant to demean, meant to intimidate, meant to harass employees on the basis of race. So that's just an overview of how anti-discrimination laws are intertwined with political speech. Now, to jump to some takeaways, federal and state civil rights statutes favor equality on the basis of many protected classifications, the purpose of them. Employers may prohibit workplace diversity, may promote workplace diversity and inclusion in furtherance of this bedrock principle. And employers are encouraged to do so. And employers need not tolerate conduct or speech by employees, even if motivated by sincerely held philosophical and religious beliefs that contravenes their EEO policies. In addition, businesses can express their own views against racism and police brutality, just to name two, but employers can continue and express their views on other social movements, particularly insofar as they found that it is important to foster a workplace of respect, diversity, equality, and inclusion. A company itself, like mentioned, has the right to speak and to control its own message regarding matters of public concern. Therefore, an employer can, in compliance with applicable laws, and that's critical, and paying special attention to some of the states that we'll be discussing shortly, that employers can create policies surrounding speech and expression and support causes it believes in, which in turn, of course, impact the workplace. As previously mentioned, policies that are created in relation to speech and expression need to be viewpoint neutral and enforced even-handedly to avoid claims of disparate treatment. For example, in the religious realm, an employer could face a lawsuit if it disciplines an employee for displaying the Quran at work while allowing other employees to exhibit the Bible. This would be truly problematic. By the same token, an employer shouldn't discipline some employees for violating the policy but not others. This is that even-handed enforcement. And most significantly, to kind of round out this discussion, employees' political expression does not take priority over workplace safety or compliance with federal or state or local anti-discrimination laws. It's important to remind employees of their compliance with the policies, remind them of the policies, that there are policies regarding discrimination, harassment, and retaliation in the workplace. And an employer's decision to address current movements and issues, which is really the top of mind right now, such as anti-racism protests, will inevitably generate discussions about these and other politically charged and controversial issues among employees who have diverse viewpoints. And there's always risk in these conversations. If not respectfully and thoughtfully considered, they will generate misunderstanding of any offensive thoughts by employees or, of course, complaints. Returning to our prior discussion, there are many points of intersection between issues of political controversy and protecting classifications under discrimination laws. Those are all to be kept at the forefront of the mind, especially now as we enter the election time. I think we've probably really entered it. But beyond the anti-discrimination laws, it's critical to consider laws regarding off-duty conduct when generating and enforcing workplace policies that may restrict political speech. In some states, employers can prohibit certain political speech and expression during non-work hours. I think we're going to flip it over to Kaveh, who's going to fill us in on some of these states.
Thanks, Victoria. Yeah, like Victoria said, political speech doesn't just occur in the workplace, obviously. Most of it occurs outside the workplace. but a few states have created kind of a legal apparatus to determine what happens when an employee engages in political activities outside the workplace. New York, for example, protects it. It makes it unlawful for an employer, even a private employer, to discipline, terminate, or refuse to hire an employee because of their political activities outside of working hours and off of the employer's premises, so long as the employer isn't using the employer's property or equipment, and so long as the employee isn't otherwise breaking the law. And the legal term political activities basically means what you think it means. It means running for public office, campaigning for a candidate or public office, or participating in fundraising activities for the benefit of any particular candidate or party. Connecticut has a similar but slightly different law that extends First Amendment protections that public employees enjoy to the private sector. So the same things we discussed earlier about whether speech is on a matter of public concern apply to private employers in Connecticut, which is a fairly big legal move on Connecticut's part. And I'll turn it over to Victoria to talk about California's take on this issue.
Thanks, Kaveh. So California, as I'm sure you guessed, is a state that offers protections for employees' politics. This slide is included more as a reference for those of you who have operations or employees in California. And the reference here also provides the applicable law. So California law prohibits employers from having a rule or a policy that prevents employees from engaging in political activities or trying to control or direct an employee's political activities. So this is it's going to get a little bit more broad than what we were discussing with New York. So now, it doesn't just mean voting, and there has been some discussion about what it actually means. It means supporting social movements like LGBTQ movements. The California Supreme Court has defined political activity as the espousal of a candidate or a cause of some degree of action to promote the acceptance thereof by other persons. So under this framework, courts have found that protected political activity includes advocating for gay rights, publicly criticizing a public official, wearing symbolic armbands, and associating with others for the advancement of beliefs. The key really is the question of, did the employer have political motive in taking action against the employee? And under that question, we could try to figure out whether or not the law could be addressed as violated. So it's safe to assume that the current definition will encompass quite a bit of conduct. And with that little bit of background, I'm going to turn it over to Cameron and Keisha, who will expand on off-duty conduct a little bit more.
Fantastic. Thank you both very much. That's incredibly helpful information and background. And just to note that New York and Connecticut and California are not the only jurisdictions that you have to think about as those that may have laws that could restrict the ability of an employer to discipline employees for off-duty conduct or their expressions of support for a political candidate or social issue. Many states have laws that prohibit voter intimidation or coercion, which might apply in the employment context. So this is not an exhaustive list, but in addition to California and New York and Connecticut, Colorado, Guam, Louisiana, Minnesota, Missouri, Nebraska, Nevada, South Carolina, Utah, West Virginia, all prohibit retaliation for engaging in political activities and have differences among them that you need to be thinking about when you're addressing situations in the workplace. Let's talk about how this sometimes comes up in employees' use of social media. And so we're going to post our second poll question now. If you take a moment to respond to the question whether or not your company has a social media policy, Many employers do. Off-duty postings on social media can create not only legal risks of potential hostile work environment or harassment claims, but can create reputational harm and real business risk. We're seeing this more than ever as employees are working remotely. They're interacting with each other on platforms like Slack and Facebook and Microsoft Teams and new ways of communicating and interacting that may enable different kinds of postings and messages, even sort of the misperception of anonymity. So it's a really good time to be thinking about updating social media policies. And even if you feel that your social media policy doesn't require updating, to be making sure employees are aware that they exist if you do have them, pushing them out, conducting training on them, not just assuming that because they're discoverable on your intranet that employees are keeping them top of mind in this remote work environment. In response to our poll question, 78% of you said that your companies have social media policies. That's pretty consistent with our experience, where many companies, do seek to apply or make clear to their employees that their EEO policies apply to employees' use of social media. Keisha, let's talk about some of the practical implications of why you would want to have a social media policy. Let me turn it over to you to talk about what functions these policies can serve.
Yeah. So from a practical standpoint, I think having a social media policy is just good business. And, the poll bears that out, that most employers do have one. I think we've all come to understand that social media brings the outside in. So we just talked about the legal landscape around off-duty conduct. And just when you thought you were safe, in walks a client or a customer with a tweet or a Facebook post made by one of your employees. And so for that reason alone, I think it's good business to have a social media policy. On a finer point about the social media policy, and you kind of touched on some of this stuff, it obviously helps to protect the company's reputation. It addresses legal issues, including the potential for blurred lines around professional and personal conduct. And I think that is what a lot of employees struggle with, especially when they are using their personal social media, but it kind of gets out in a way that, again, brings it back into the company. A policy would certainly help minimize confusion about what is and what is not appropriate behavior. And I think it can offer suggestions about appropriate ways to engage with others, particularly when doing so in the name of the company. Now, again, you have, and we'll talk about this a little bit later, there are certain things you need to be thinking about in terms of the NLRA, but I do think it is just good business to have a social media policy. I won't restate points we've addressed, but suffice it to say, all of the other points we talked about in terms of a political speech policy, you should also be thinking about in terms of a social media policy. I think it's wise to cross-reference your EEO policies or other relevant policies within your social media policy, and that just sets the expectation about how we want to address things, what we want to address, what we need to address, and to let employees know that their conduct can have broader implications. So it's not just that it's, a violation of your social media policy potentially, but it could also be a violation of your anti-harassment policy or other EEO policies. And I also think, you're thinking about human behavior. And there's something to me that hits just a little bit differently if an individual thinks they're running up against the anti-harassment policy versus a social media policy. I think that may cause people to have a little bit more of a reflective pause before acting. And so I think that's also a good reason to cross-reference those policies. You know, as a healthcare company, I will tell you that social media is something we take very seriously. We serve a very large population, people from all racial and ethnic groups with different political, religious, economic, and other views. And a primary component of how we connect with and maintain relationships with our members has to do with trust. And it's trust on a very personal level because we're dealing with people's health and the health of their loved ones. And so can you know, I think about being a member, and I couldn't imagine living in a small town with access to just one clinic and having to receive critical health care from a person who just posted their general disdain about people who I personally identify with, from, you know, be it race, religion, gender, sexual orientation, et cetera. And so you may wonder if those comments and beliefs can be bifurcated from the care you receive. And so for a company like United Health Group, you know, even beyond kind of reputation and brand, with a mission like, you know, helping people live healthier lives, helping the health system work better for everyone, this is something that is very important to us. So we have to be very mindful about how we manage social media. Again, it's a fine line, but I think it's good business for the majority of companies to make sure that they're keeping, you know, tabs on this, that they have their hands on the pulse of it, and they know, and they have a good policy.
Great, thank you, Keisha. I got a question. Are those real life examples? These two at the bottom of the slide. In fact, they are. In 2018, a woman in Virginia who worked for a nonprofit she was fired for flipping off President Trump's motorcade, and she brought a wrongful termination suit and lost. She later ran for public office and won, so she's gainfully employed. But you know, whether or not this kind of activity is protected will also depend on what state it occurs in, right? So whether it's truly off duty, because there may be protections on the state or the local level, you know, that provide greater or lesser protections. Okay. Let's move on to our first hypothetical. Keisha, we're going to continue to discuss. So here you have an employee A who posts a selfie at a weekend Black Lives Matter demonstration with the caption, "Remember George Floyd." And employee B is offended by this post and brings it to your attention. So, Keisha, what would you do if this came across your desk? How would you advise, you know, a supervisor who's just fielded a complaint from employee B about having seen employee A's post?
Yeah. So in assessing this particular situation, I think I'd start, and not even this situation, all situations, I'd start with identifying exactly what we're dealing with here. And so what we have in this particular situation is activity on social media, and embedded in that post is also attendance at a demonstration that presumptively both are off-duty and lawful conduct. And then you have an employee who was offended by the post. And I should have put offended in air quotes because I think that is one of the gray areas that we struggle with, that we have to grapple with. And more specifically, what behavior or conduct or speech should reasonably or objectively be classified as offensive. From an objective standpoint, the statement, "Remember George Floyd," doesn't strike me as disrespectful. There's no profanity in the post. The words themselves are not harassing or threatening. The statement is not defamatory. It's not targeted at one person or a group of people. And unless the employee making the post is, you know, in the county attorney's office or the DA's office or a similar role, I don't see it as exposing the company to liability as a general proposition. So what we have here is lawful off-duty conduct. Even though it was brought into the workplace by an aggrieved employee, it doesn't strike me as something that would violate the company's social media or other policy. But then you still have the second piece, which is that there is an employee who was offended. So, you know, I think about that because it's something I think you have to address, you can't shy away from. But by definition, whether something is offensive is generally a personal assessment, which means that something that offends one may not offend others and vice versa. And so the upshot is that assessing one employee's conduct by whether or not he or she found it to be subjectively offensive is probably not the best way to go about these matters. My recommendation would be to tease out the action, the post, the comment, and then conduct an objective assessment around whether it's disrespectful, is it defamatory, is it profane, is it harassing, threatening, is it consistent or inconsistent with company messaging and the culture, and then assess the conduct on those factors. But again, I don't think you can shy away from employee B because he or she likely is personally offended, and that's something that you'd have to also address. You know, I'd recommend having a conversation with that employee to acknowledge his or her feelings, to reiterate the company's policies around political speech and the like, social media policies, respectful workplace, et cetera. And so it's really to manage expectations across the board. So you're managing the expectation of that employee as well, because you could run into a situation where they're offended about that today, and then they're offended about something else tomorrow. And so I think it'd be good to lay the groundwork so that they understand what the company's policies are, what are our limitations, you know, what we regulate, what we don't regulate, et cetera. And I'd just like to add a caution here because there will be some things that will violate the policy and there will be some things that don't. And so I think we have to be comfortable knowing the difference between those things, and not every comment, post, et cetera, that one employee finds personally offensive is going to be a violation of the company policy. I think the ultimate question here is, what do you want and or need to regulate or control? And is an employee's Facebook post like this one or something similar something you'd want to regulate or prohibit?
Keisha, I love that point about really engaging with employee B, you know, and that you know, it's an opportunity to really sort of get under the hood a little bit with employee B and have a discussion about why they feel offended. And obviously, you need to be careful about how you do that. But we don't want to take away from our presentation today to be that these issues are too hot to handle and that we can't talk about race in the workplace. But in fact, you know, that we can have productive, even transformative and respectful conversations about race, about social issues, about difficult issues in the workplace. And that may all contribute to, if done right, greater productivity, better employee morale, you know, all kinds of good things. Let's talk about our next hypothetical and whether we come out any differently on this one. Here we have employee A who makes a scathing rebuke of the recent Supreme Court decision protecting LGBT employees and applicants against employment discrimination, and in so doing uses offensive epithets about LGBT individuals. Employee B complains that the post is offensive. What do you think, Keisha? Is this different at all? How would you address this one?
Yeah, you know, the same formula applies here. So a review of any relevant laws around off-duty conduct, depending on your state or city, an assessment of whether any workplace policies are violated, et cetera. I'll cut to the chase here and say that I'd advise my HR business partners that this particular post is a violation of company policy, and it may be one policy or it may be several policies. So just breaking that down, a scathing rebuke of an opinion is one thing, and, you know, we'd need some more detail around, you know, what that rebuke entailed. But what we do know is the employee used offensive epithets. Now, again, caution on the use of offensive and how that's interpreted, but considering that term coupled with that they used used offensive epithets, it likely means the individual made some remarks that categorically grouped in individuals who are LGBTQ, negatively, possibly disrespectfully, and in all likelihood in a way that violates the company's anti-harassment or discrimination policies. And so that's not something we would tolerate in the workplace or social media. So when comments like that, off-duty, find themselves or find their way back into the workplace, either by a coworker or a client or a customer, I think, you know, the net here is that even though employee A could argue, well, this is political speech and, you know, it was done off-duty, we can regulate it when it gets to this point. So the issue is not whether it was political activity, but rather was there something that was inappropriate associated with that conduct or with that activity. And my assessment would be in this particular situation, it was. So, and I think this is also another plug for why you should cross-reference your EEO policies in your social media policy.
Exactly. Yeah, and I think really, is it, you know, are these comments targeted towards people as well? Like, and you know, that's a real distinction between these two scenarios, whether there are offensive epithets about LGBT individuals. So I think, Keisha, those are all great points for people to be considering as they are facing these kinds of scenarios. Victoria, let me turn it over to you to maybe just give us the headline in the interest of time about religious and political objections to training and policies on EEO.
Thanks, Cameron. Yeah, of course. So just briefly, we've seen and we expect that we'll continue to see a more heavily litigated area here with trainings and in trainings specifically for inclusion and diversity. So there are a bunch of states and cities that now require trainings to be delivered annually, and those include New York City, New York State, Connecticut, and California. And many employers intertwining those trainings have taken them to the next level to talk about bystander intervention strategies and strategies for encouraging inclusion and belonging. And recently, President Trump has issued an executive order which, for federal contractors, prohibiting training on implicit bias and other aspects of EEO training. So we really expect that there will be this area of religious and political objections for non-discrimination laws for training to be a flashpoint. And really the crux of this is, what should employers do when they're faced with religious and political objections to workplace anti-discrimination, anti-harassment trainings and policies? Well, employers are free to require such trainings, and by law, some of the trainings must be followed. And employees do not have a right to opt out of this training based on religious or political objections. But caution there is that certain states may restrict the employer's ability to discipline an employee for criticizing the content of a training if couched in a political opinion. And those include Connecticut, for example, where you can imagine an employee during an EEO training saying that she disagrees with a recent Supreme Court decision that extends employment non-discrimination protection to LGBT individuals. In Connecticut, for example, the disciplining of such an employee for the content of that opinion would be problematic, and even if it's consistent with the company's values and policies. So this is just a quick overview of the objections we have heard and anticipate seeing more. So I'm going to turn it over to Kaveh to talk a little bit about the NLRA.
Sure, thanks, Victoria. The NLRA is kind of its own, traditional labor law is its own discrete body of law and has been for a long time. But for purposes of today's conversation, the NLRA protects certain concerted activities of employees for purposes of mutual aid or protection. That's the statutory language. In plain English, what that means is that the NLRA is primarily concerned with an employee's ability to work with his or her fellow employee with the aim of improving their work conditions. So in the context of political speech, what does that mean? It means that the NLRA protects political speech that relates directly to the terms and conditions of employment. So for example, if employee A and employee B are talking about, increased benefits in the workplace, that has a political shade to it, but it's primarily directed to the terms and conditions of their immediate employment. On the other side, political speech that's unrelated to employment is not protected by the NLRA. So for example, handing out Biden-Harris pins at work is not protected by the NLRA, even though, ultimately a Biden-Harris presidency may have, a tenuous impact on your terms and conditions of employment. It's too attenuated to trigger the NLRA. And this was reiterated recently by NLRB guidance. The issue was with whether an employer could terminate an employee for working on police transparency legislation in his capacity as a state delegate. And the NLRB held that because the employee's political activities had no direct impact on the employee's wages or hours or other working conditions, it was not protected by the NLRA. Instead, the employee was more acting in the interest of the community at large. And the NLRA, frankly, doesn't care about those types of political activities because they have no direct impact on the employee's working conditions.
Great, thanks, Kaveh. So we'll turn to our next hypothetical that covers some of these issues. An employee wears a pin that says "Increase the minimum wage, vote blue." So, Keisha, what do you think? Do you think the first part, "increase the minimum wage," gives the whole statement protection under the NLRA? Is this protected concerted activity, or is this political speech that would fall outside the NLRA? I assume people can really disagree about this one, but I'm curious to hear your thoughts.
Yeah, I think you could go either way here. It's always a close call on these particular issues when viewed in light of the NLRA. I'd likely lean toward it being more political. Vote blue is clearly political because it has no relation to a union or working conditions. Raise the minimum wage, I think that's the piece that is kind of gray. But it could also be seen as political because it points to a push for a change in legislation. And then that's buttressed by the fact that the suggested action is to vote Democrat or blue as a means to accomplish that. By contrast, an employee wearing a button that reads "Raise our wages" could be purely NLRA activity if it's for a group of people, and then that would be protected. Again, I think these are close calls and would also depend on who is on the NLRB. I could see a more liberal board saying this type of statement is related to terms and conditions, and a more conservative board taking the opposite view.
Absolutely. Before we cover the next hypothetical, I just want to read the CLE code, which is SS0091. So that's SS as in Seyfarth Shaw 0091. Okay, our last hypothetical for today, employee A wears a mask in the office with the letters BLM on it. Employee B brings this to the supervisor's attention and says that he takes offense. Employee B asks the supervisor either to tell employee A to change masks to one without any writing on it, or to permit employee B to wear a MAGA mask as a counter message. Mm-hmm. So now this is maybe our trickiest one of all. But Keisha, how do you think the supervisor should deal with this situation?
This is where your policy is going to be your friend. And the best thing to do is to have a neutral dress code policy. Again, and while I'm on that point, I just want to put a plug. Now's the time to update those policies because these situations will happen. And particularly here when we are in a situation where people are wearing masks and you have, and they're in your face. It's not like, a button here or something that maybe someone wouldn't see. If you have a BLM or a MAGA mask, I mean, it's up front, right up and personal. So, you know, I think, again, you have to go through the process. Any law applicable, what's your company policy? And I think this is also a situation where you need to be aware of any positions your company has taken publicly on the matter. So you mentioned this was a complicated situation, and I'm going to complicate it a little bit further by saying if your company has made, you know, taken a public stance on, you know, we support Black Lives Matter movement, then you could potentially really have a situation, because then the employee who wore the mask, the BLM mask, could say, well, you said this publicly, do you actually mean this? And if you do, then why is there a problem with me wearing this? And so again, that's where if you have a neutral dress code policy, that's probably gonna be the best situation here. And also I think you wanna think about, do you wanna regulate this type of thing? There's another component where it's depending on your industry. So we think about a healthcare company, right? We have an insurance company, but we also have a care delivery organization. And that's the part of the business I support. And so you have people who are wearing lanyards. They are really interacting. They're wearing masks, obviously, but they're interacting with the public constantly. And so you want to ask yourself the question, is it okay for individuals to wear, you know, a MAGA mask or a MAGA hat or a Black Lives Matter mask when they are going to be interacting with the public? Because then it goes beyond just employees. Then you could potentially have a customer issue or a client issue, and you know, do those messages make people feel more or less welcome? And so that's also another consideration. You know, I think this is it is the stickiest situation we've talked about. And again, I think the best thing you can do is to say, we have a neutral dress code policy, and so we don't allow individuals to wear statements on their dress, especially when they are if they are client facing or customer facing. And the finer point is, I think you can still go out publicly in support of certain things and have a neutral policy. The point is to make sure your policy is there when you need to rely on it.
Yeah, this is interesting, Keisha. So in response to our poll, 54% of respondents said that their company has taken a public stance on Black Lives Matter. That's actually higher than I would have thought, because this can be such a tricky issue in that you know, there is some difference of opinion about whether Black Lives Matter is a peaceful social movement, a social cause only, or whether it's a political position. And there really isn't one answer to that, you know, for all employers.
Right.
So, you know, I think also in thinking about this, the counter message, is that counter message directed specifically to that employee? Is it designed to intimidate or harass? And we always have to remember that political and religious speech or claimed exceptions are not, you know, bases to not comply with employers' non-discrimination and harassment policies. So, Keisha, we touched on a number of the sort of practical implications of restricting speech and expression, but I just want to sort of call some of these out expressly. I mean, it seems like the safest course of action is just to ban political speech, right, in the workplace, either expressly or through other workplace policies like your dress code or your code of conduct. But, you know, that may really contribute to some negative effects like bad publicity or poor employee morale. You know, what are your thoughts on the potential downsides of more restrictive speech policies?
Yeah, I think the two you mentioned, bad publicity, poor employee relations, those are two primary ones. And not only the bad publicity is it can actually cause, poor employee morale as well. So they can work hand in hand. And then you have some companies where people have actually started to protest or they make other posts. And so it just kind of blows up. And then I think, again, it is naive to think that people won't talk about politics or social issues in the workplace. And going way back to our first hypothetical, it's like, what type of workplace do you want? What do you want the environment to be like? What do you actually want to control or think you need to control? And so I think some of all of that would have to go in your assessment as to whether you have something that is very restrictive. I will say the one thing that all of us should keep in mind here is this is not something that we should or really can shy away from. And so I think what employers need to do is be honest about what their policies are and be upfront about them. As you mentioned earlier, Cameron, don't just have a social media policy and have it somewhere, nestled in your intranet where people have to click, several times to be able to find it. I think just like situations where, we have the Me Too movement and other things, you need to be upfront and put this out there. We don't live in a bubble. We understand what's going on right now, and here is our position on it, and here are our policies, and really level set and set the expectations for employees.
Yeah, I think that's absolutely right. It's clear that employees are going to talk about politics. We know they are, but it's a matter of thinking about how we might be able to direct some of those conversations into places where they can be mediated and moderated, affinity groups, mentorship relationships, and being clear with employees about what the parameters are should they engage in those discussions, and that, our workplace policies that prohibit harassment and discrimination will continue to apply in areas of employees' use of social media. In terms of, as we wrap up today, some takeaways, it's clear that companies are free to engage in expression and taking positions on political issues, but we always need to be aware of discrimination or harassment concerns and the even-handed and neutral application of workplace policies because of the Nlra and state-level off-duty conduct and other laws that may provide protections for employees' political speech or advocacy on behalf of the social movement. But that this is such a polarized but exciting time to be thinking about how to craft a workplace culture that is truly celebrating inclusion and belonging, and part of that is embracing diversity of opinions and encouraging employees to have sometimes difficult conversations, but always in respectful ways. I know that we're at our time today. We've tried to answer as many of your questions throughout our presentation as have come in through the Q&A chat function. However, to the degree we haven't been able to address any of those specifically, we'll follow up with you directly to make sure that you get answers to your questions. Once again, the CLE code for today is SS, as in Seyfarth Shaw, 0091. And you only need one CLE code for today's presentation. Thank you so much for being with us today. Thank you to the fabulous Keisha Mays for joining us on our panel. Victoria and Kaveh, thank you. And I hope you all have a wonderful rest of your day. I'm going to leave you with one thought. What I hope is a non-political statement. In 3 weeks, or if you're able to before then, vote. Thanks, everybody.